Hi everyone, welcome to Legal Talks by Desi Qanun. I am Suyash and I am excited to have started this show. On today's show, we will talk about yet another important judicial pronouncement by the Honorable Supreme Court of India in the case of Kotak Mahindra Bank Pvt Limited versus Ambuj A, Kasliwal and Others. In this case, a question arose with regard to the correctness of an order passed by the Debt Recovery Appellate Tribunal DRAT as well as the High Court in a matter relating to pre-deposit of debt due in an appeal before the Debt Recovery Appellate Tribunal. In the present case, the DRAT or the Debt Recovery Appellate Tribunal had ordered deposit of 50% of the amount. In order to further understand this controversy, let us understand Section 21 of the Recovery of Debts and Bankruptcy Act 1993. Section 21 talks about deposit of amount of debt due on filing appeal. What is Section 21? This has been explained by the court. According to the court, Section 21 employs the phrase appeal shall not be entertained. Section 21 contains this phrase that appeal shall not be entertained unless and until the condition of pre-deposit is satisfied. So, the court observes that this indicates that it injuncts the appellate tribunal from entertaining an appeal by a person from whom the amount of debt is due to the bank unless such person has deposited with the appellate tribunal 50% of the amount of debt so due from him under Section 19 of the Act. The proviso to the said section, that is the proviso to Section 21, however, grants the discretion to the appellate tribunal to reduce the amount to be deposited for reasons to be recorded in writing, but such reduction shall not be less than 25% of the amount of such debt which is due. Therefore, in light of Section 21 and in light of this interpretation, the court opined that the High Court does not have the power to waive the pre-deposit in its entirety, nor can it exercise discretion which is against the mandatory requirement of the statutory provision as contained in Section 21. Thus, any waiver of pre-deposit to the entire extent by the High Court would be against the statutory provisions and therefore not sustainable in law. These were the observations by the court. So what was held by the court? The court further explained Section 21 and considered an analogous provision contained in Section 18 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, that is, the SARFAESI Act. Section 18 relates to pre-deposit in order to avail the remedy of appeal under the SARFAESI Act, and the court considered its interpretation in the case of Narayan Chandra Ghosh versus UCO Bank 2011 4 SCC 548. The crux of the reasoning by the court could be divided into 4 parts. The first part is that there is an absolute bar to entertainment of an appeal unless the condition precedent, that is the condition of pre-deposit as stipulated, is fulfilled. The language of the provision is quite clear, that is the language of Section 21. It is quite clear and admits of no ambiguity. Secondly, according to the court, it is well settled that when a statute confers a right of appeal, while granting the right, the legislature can impose conditions for the exercise of such right, so long as the conditions are not so onerous as to amount to unreasonable restrictions, rendering the right almost illusory. Thus, the condition of pre-deposit must not be too onerous. Thirdly, according to the court, no court, much less the appellate tribunal, a creature of the statute itself, can refuse to give full effect to the legal provisions. And lastly, the court stated that a total waiver of the condition of pre-deposit would be against the statutory provisions, as we have seen in the case of Section 21. So that is the entire crux of the reasoning adopted by the Honorable Supreme Court. And what are my concluding remarks? I feel that this is another case by the Supreme Court wherein it had to conduct an interpretative exercise to understand the true purport of a legal provision. Condition of pre-deposit is something that may act as a technical barrier against the right of appeal of a litigant if the bar of deposit is too high. However, DRT, that is the Debt Recovery Tribunal, and Debt Recovery Appellate Tribunal are tribunals that deal exclusively with financial and banking disputes wherein money is of prime importance. It is equally true that unscrupulous parties try to take advantage of the legal proceedings to shy away from paying the banks their lawful dues. Thus, a holistic and a balanced view is required to be taken, and this would suggest that as long as the condition of pre-deposit is onerous, it is not to be sustained by the courts. And if the condition of pre-deposit is not too onerous, if it is balanced, then it has to be sustained by the courts. Though I concur with the reasoning of the court, yet, in my humble opinion, the legislature must consider bringing about a change in Section 21 of the Recovery of Debts and Bankruptcy Act 1993 and further reduce the bar in relation to pre-deposit. We saw that the court or the tribunal has the discretion to lower the bar in relation to pre-deposit up to 25%. However, due to COVID-19, many people are suffering immense financial hardships, and the legislature must be cognizant of this fact. The financial power of people in general has diminished considerably, and in such a scenario, the precondition of deposit of 50% of the amount due or even 25% is something that may be excessive for a person who is on the verge of bankruptcy. For the time being, it is my humble opinion that it would be appropriate for the legislature to reduce this bar of pre-deposit to 10% or even lesser. It may even waive this bar. So I hope you enjoyed listening to this show. Thank you for listening, and please do not forget to like and subscribe us. See you next time. Till then, stay tuned.